The next speaker this evening, you all remember as the former Chief Justice of India. Enrolled to the bar in 1977, Justice Mishra has spent 22 years as a judge, starting from the Odisha High Court, the Chief Justice in Patna, then Madhya Pradesh, then as a judge of the Supreme Court, and finally retiring as the Chief in October 2018. Let's please put our hands together for Justice Deepak Mishra.
Sri Arjun Ram Meghwal, Honorable Law Minister, Mr. Falias Nariman, Senior Advocate, Mr. Mahesh Jethmalani, Senior Advocate, Mr. Sham Devan, Senior Advocate, Mr. Gurumurthy, Mr. Kartikeya Sharma, Member of Parliament, Mr. Goswami, ladies and gentlemen. Today, I must say, without any kind of hesitation or innovation, that it's a great day. I always appreciated late Ram Jethmalani for three fundamental, perceptible reasons. In the year 2011, Mr. Nariman, Mr. Jethmalani, and myself shared a platform in the university. I quoted two lines from a Sanskrit prescription on how a plane should be drafted. I had translated it into English. Late Jethmalani asked for a copy and told me, I am not asking you just like that. I want to feed my curiosity. That was the great intellectual curiosity of late Jethmalani. The young students or the young lawyers who are present here today must understand and try to develop the intellectual curiosity. In that speech, he spoke a line. Whatever I do with a clear conscience. Look at the courage of the man. Third, whatever I have read and learned by meeting him, he had an incomparable presence of mind that epitomized originality. Today, with the Centenary lecture, I feel proud and honored to be a speaker here. Presently, let me focus on the topic. Has the basic structure doctrine served the nation itself? Nation well. According to the scientists and the rationalists, if you pose a question, it is fundamental to proceed in an empirical manner, and then only you will get a correct answer. Having scanned the anatomy of the question, which has been extremely intelligently framed by Mr. Mahesh Jethmalani, the answer should be given with utmost immediacy. And the answer is, ladies and gentlemen, a capital yes. It has served the nation well. To elaborate, the basic structure doctrine has served the nation and saved and stabilized the constitutional democracy and the core values with excellent solidity and virtuosity. I deliberately add this word virtuosity without allowing any space for doubt. Why do I say so? I cannot make a statement if they Dixit and rest. I am obligated as a student of law to give reasons. When any doctrine is discussed, it's necessary to pose three questions. Firstly, the validity of its origin. Secondly, serviceability of the same for the cause it's conceived. And thirdly, necessity of its continuance tested on the progressive parameters without adopting a doctrinaire pedantic approach. Before I proceed to state the justness of the doctrine, the origin of it, which I would like to call cause of the cause, or for that matter, essence of the essential, has to be kept in mind. It is the summum bonum of our constitutional jurisprudence. That is, the Constitution is sovereign and its supremacy is unquestionable. There is no necessity to think that the judiciary is trying to reign supreme. Judiciary functions under the Constitution and follows the constitutional values, norms, conventions, framework, silences, or abeyance. Let's go in the history for a moment. Initially, the Supreme Court understood Article 368 in the literal sense. The real test arose in Gorakhnath, where court had to deal with many an amendment. Prior to that, two learned judges had expressed strong dissent in Sajan Singh. In Gorakhnath, the view the court took eventually led to spate of amendments and gave rise to Keshavanand Bharati's case. The principle laid down there is well known. Because of prolixity of judgments, a senior counsel wrote a book and got it released in 2011, stating that the majority view in Keshavanand Bharati is not the ratio. I must tell you, the view is totally wrong. The ratio is absolutely clear. The Parliament has the power to amend the Constitution, but the power is not unlimited. It doesn't have the power to amend the basic structure of the Constitution. The majority of the judges also discussed some of the features of the basic structure doctrine. They can be encapsulated as rule of law, supremacy of the Constitution, democratic form of government, judicial review, independence of the judiciary, separation of powers, the secular and federal character of the Constitution. It was stated that the basic features are easily decipherable from the entire constitutional scheme. I really don't understand why the Lawrence Senior Council and many others still think the ratio is not clear. Scrutinized oppositely, three aspects emerge. Firstly, the majority view is clear as day with regard to the nature and character of Article 368 of the Constitution. Secondly, given the power to amend, the article cannot be taken recourse to, assume unlimited power, or destroy and abrogate the Constitution, or to put it differently, in exercise of the said power, the identity and personality of the Constitution cannot be altered. Thirdly, the Constitution being supreme document, the basic features are unamendable. The interpretation is within the keen understanding of the Constitution. It's neither extra-constitutional, nor alien to the Constitution, nor meta-constitutional. It encompasses every facet of the Constitution to establish the ground norm, that is, unchangeability of the identity of our organic Constitution. All of you, I assume, must have gone through this decision. I am compelled to say, being intellectually bound to my concerns, that the origin of the doctrine is flawless. Chief Justice Sikri quoted a passage from the decision in Reed versus Baldwin. Look at the poetic prose. It states, in modern times, opinions have sometimes been expressed to the effect that natural justice is so vague as to be practically meaningless. But I would regard them as tainted by the perennial fallacy that because something cannot be cut and dried or nicely weighed or measured, therefore it doesn't exist. I can speak with certitude. All of you present here and all of the members of the great country, the citizens, and who are not there, can never say now that the principle of natural justice is vague. Any lawyer worth his salt will always argue natural justice cannot be ignored. Similarly, basic structure doctrine can never be ignored. How to test a doctrine? The correctness, acceptability, serviceability, and the solidity of any legal theory is put to test when the occasion arises. The basic structure doctrine did not have to wait long. In 1975, Article 329A by 39th Amendment came into existence. The said amendment made an, shall I say, adroit endeavor or maladroit effort to immunize the elections of the Prime Minister and Lok Sabha Speaker from scrutiny by the judiciary and further to nullify the judgment of the Allahabad High Court. The Constitution Bench, presided by the Chief Justice N. Roy and Indira Nehru Gandhi, said that the court was proceeding with the hearing on the assumption that it is not necessary, I repeat, it's not necessary to challenge the majority view in Keswanand Bharati's case. I must say and remind this House, it was eventual acceptance by the non-believer in basic structure doctrine. I'll refer to another amendment, Mr. Nariman has dealt with it in a different way, that came in quick proximity, the 42nd Amendment. It had been brought with the intention to reduce the power of judicial review, to treat the directive principles of state policy to a primacy over fundamental rights, and further asserting parliamentary supremacy or parliamentary sovereignty by state, stating that no constitutional amendment can be called in question in any court on any ground. By the said article introduction to 368, all fundamental articles, if I am permitted to say, went to the Arabian Seas or the Bay of Bengal. They fell into insignificance. The harmony between Part 3 and Part 4 of the Constitution was destroyed. When challenged, Chief Justice Y.B. Chandrachud in Minerva Mills case said, since the Constitution had conferred a limited amending power on the Parliament cannot, under exercise of that limited power, enlarge the very power into an absolute power. By the 42nd Amendment, the real essence of the Constitution was destroyed. The court did the needful. Mr. Arnab Goswami raised a question today that should be a debate. I must ask a question to everyone and every curious student of law. What would have been the fate of this nation and its citizens had not the court taken aid of the basic structure doctrine and declared the disturbing part of 39th Amendment and wholly unacceptable and devastating amendment occurring in 42nd Amendment as unconstitutional. The result would have been the cherished ideals and marrows of democracy would have been guillotined, and the nation state would have faced, to quote a phrase from great John Marshall, a solemn mockery of the Constitution. And more significantly, the real judicial review would have melted into nothingness, and the citizens of this great democratic polity would have turned into subjects. I hope all of you understand the distinction between a citizen and subjects. I must refer to NJSC case. All of you know the amendment was struck down as that infringed the judicial independence, which is a basic structure of the Constitution of India. In Iyer Coelho case, the 9 judges unanimously said, you cannot put a legislation in the 9th schedule and say it is immune. What has it actually done? If you go deep, think deep, it has really empowered the citizens of India not to suffer an impermissible law because of grant of immunity. An impermissible immunity. Now let's come to the rights test. The rights test and the concept test have put the individual rights and constitutional values on the elevated platform. The citizens' rights recognized under the Constitution, according to me, can never be marginalized, and it would not have been possible without the basic structure doctrine. Since that every individual right would have paled into total insignificance. There would have been no expansion of Articles 14, 19, and 21. The apex court could not have propounded the values of individual dignity, privacy, choice, freedom of expression, equality in the true sense, gender rights, constitutional tort, and other aspects, all founded on acceptable, realistic constitutional principles. The entire nation state would have paved on the path of regression, and the citizenry rights would have gradually moved into unredeemable hollowness. There can be no scintilla of doubt, no trace of doubt, no speck of doubt that the basic structure doctrine stabilizes constitutionalism, constitutional governance, rule of law, and legitimizes all actions. Let it be told today that the basic structure doctrine is one that is directed against anarchy. It has basically acted a navigational compass to enable the judges to navigate the journey of constitutional interpretation in the proper direction, and also guided and enriched our constitutional progress. It is the elan vital and the filament of the constitutional principles and values. In conclusion, I would like to say that the basic structure doctrine is neither an enigma nor in the realm of mysticism. It is here in the elements with true fixed continuing quality. I repeat, it is here in the elements with true fixed continuing quality. Why? To serve, protect, and shape the nation, because it is the spirit, fundamental essence, and conscience of the Constitution. None of us should forget that basic structure doctrine remains the most natural constant. I borrow these words from physics. Natural, constant, and diligently searched rock. I borrow these words from philosophy. Diligently searched rock of our constitutional democracy, and philosophy. Never mortgage our constitutional democracy. Never, never barter it. Thank you very much.
Justice Mishra, many, many, many thanks. Our next speaker this evening is one of the most impactful, unabashed, and influential voices in the country, a chartered accountant who wields his pen as the editor of Tughlaq. He's never shied away from either telling truth to power or controversy. Let's give a welcome round of applause to Swaminathan Gurumurthy.
Honorable Minister Sri Arjun Mengwal, Justice Deepak Mishra, my friend Fali Nariman, Mr. Shyam Diwan, with whose father I had very intense relationship, and he was one of the persons who molded me, and Arnab Goswami, my good friend, and Mahesh, who thought of inviting me because he felt that there should be a voice outside the jurisprudential group, which is both the judges and the lawyers put together. You know, it is my fortune, my pride, an opportunity for me to share my thoughts, not as a lawyer, but as someone who had come in contact with law, fell in love with law, became passionate about law, because of a series of accidents, coherent accidents, which took place in my life, starting from emergency and the days before. You know, we were all underground at that time. We couldn't go to our houses. And I had just then qualified as a chartered accountant and got married also. So, it was at that time I came to know the essence of the Constitution, the fundamental right, the need for it. Otherwise, it was just a piece of paper. Nobody knew what fundamental right meant before probably the emergency was imposed. Very few people knew about its impact, maybe most in the field of commerce or property. There was no idea of what it means to the normal, ordinary human being. I was given the responsibility of maintaining 150 families to provide rations for them who were in jail. They had done nothing wrong. So I knew what it means to have fundamental rights, to be outside, how to approach the judiciary. This is what made me to study the Constitution in depth. In fact, emergency became the first major impact on me to study the Constitution. And before I go into what transformed me from being a chartered accountant into someone who had developed such passion for law, I will talk about Ram Jethmalani. You know, Ram and Fali and people like them are the ones who groomed me, encouraged me. And they found that, you know, I was not a lawyer, but they never discriminated my ideas on law. I could put provocative questions to them, contrary questions to them, even questioning their very idea about what they were proposing to argue in courts. They would tolerate it, they would encourage it. In fact, I was just sharing with Fali Nariman how in the Indian Express demolition case we worked. He said how much work we put. He also said how little work is being put today by the bar. It's a comparison. How the government of India functions, from the allocation of business rules to the authentication of document rules. Because the government of India said the secretary signing on behalf of the government of India doesn't have the authority to give sanction for the building plan. The government disowned the whole thing. So we had to construct the whole Article 73 downwards to how a secretary signs, meaning the President of India signing. It was a 72-page affidavit which he had to file in the Supreme Court because the government disowned its own signature. This is how law develops. Law develops by hard work, by the passion to fight for rights. So, when I started with Ram, he was one of the most comfortable human beings. First of all, leave law aside. Such a comfortable human being. I said, Ram, you are wrong. He will listen to it. We will all be shouting and talking. He will be reading as if nothing is happening outside. And he will read the judgments which were quoted against him. And we would have 20 judgments in favor of what we have to speak. Ram will find fault in the judgment that have been quoted. And he will say that to find holes in the judgments of the opponents is what will win the case for you. Not that you quote alternative judgments to present your viewpoints. These are all brilliant legal strategies to which I was initiated when I was just 27, 28. An opportunity which I got purely out of accident of being the advisor to Ramnath Goenka, who had to face the toughest time in terms of government attack on him during the emergency and afterwards, even after the emergency, the building demolition case, the customs duty case, and all the cases that were launched. 300 cases were launched in a period of 30 days. All these things we had to fight, and perforce we had to become lawyers. In Indian Express, almost 6-7 people who had nothing to do with law turned to be good lawyers, thanks to the kind of assault that the government made. And we had to defend that institution and the civil rights which the institution represented. That's how I came in contact with Fali. That's how I came in contact with Nariman, Anil Diwan, to stay. It all started with Nani Palkiwala. Then Sirwai. I will tell you some of these things, this anecdotal effect of the association I had with all these people. Unbelievable. No university, no law textbook, no library can give the kind of knowledge which I could get by my association with these people. So about Ram. You see, Ram, somebody asked how many times he was Rajya Sabha member. I think our minister asked. He was a Rajya Sabha member 4 times. Of course, he was in Lok Sabha. He was in Rajya Sabha member 4 times. He was Shiv Sena Rajya Sabha member. He was Janata Dal Rajya Sabha member. He was BJP Rajya Sabha member. And he was RJD Rajya Sabha member. He completely unified India. The man had he had a huge heart. In fact, he told me, Guru, will you help me to defend Lalu Yadav? I said, Ram. You see, Ram and me had a very open exchange on many issues. You see, I was also called a crusader against corruption. I would always screen a client 20 times. I will take certificate from my friends that I can take him as a client, because tomorrow somebody should not say that I have taken a wrong client or benefited by a wrong association. But Ram will take the most acknowledged rascal and defend his case. And still he was called a crusader against corruption. I said, Ram, how lucky you are. We are giving up 90% of our opportunities to get the name that we are fighting against corruption. But you are able to fight against corruption, call a crusader against corruption, and at the same time represent these people and make money out of them. In fact, a very interesting dialogue took place between Ramnath Goenka and Ram Jethmalani. In fact, Fali Nariman will be very happy to listen to that. Ramnathji is one of the greatest pride is that none of the senior counsels would charge him. Guru, Nani doesn't charge me. Fali doesn't charge me. Ram doesn't charge me. Soli doesn't charge me. Ramnathji used to feel so proud that these great guys are not charging him. In fact, he showed me the bill which Fali Nariman had sent after completing the arguments on the demolition case. And almost 35-40 days the case went on. I think it was after the Keshavananda case, it was the longest case argued before the Supreme Court till then. So when that bill showed that Fali had charged him only for the clerkage. He must have shown that bill to Fali. He must have shown this to 100 people, not to praise you, but to make others feel how important Goenka was. So you must understand, Arun Shourie used to say, Goenka is Article 19(1)(a). He represented the freedom of India. It is not the press freedom of today. You know, those who had worked in the Indian Express those days, the kind of troubles they had undergone, salary deferment, salary cut, these are all the things which journalists underwent to defend press freedom. So Article 19(1)(a) was represented by Ramnath Goenka at that time. And so Ramnath Goenka asked Ram, you are defending so many people pro bono. How are you making your money? And Ram said, that's a very simple formula, Ramnathji. I make money depending upon the trouble my client is in and the weight of his purse. This is how he said, I make money so that I can do pro bono work. You know, these are all things. With how many tall people we moved. Where are those tall people today? In fact, this is how I am going to end my speech. That what we need today is not tall legal brains, not tall judges, not tall media men, but tall people. Tall men, sun crowned. This is what we need. Now, going into what is my personal qualification to be here. You know, I am a chartered accountant, but chartered accountants think I am not a chartered accountant, I am a journalist. Journalists think I am not a journalist, I am a chartered accountant. But I am happy ultimately somewhere I have been asked to share my thoughts on a subject on which I have developed some empirical skills. And I am happy this audience of people of jurisprudence are listening to me, which even my own profession and the adopted profession as a journalist has not afforded me the chance. So my first qualification is that I am a friend of Ram. That is why I first felt that I should be present here. And my next qualification is that I have to label to prove to you that my introduction into the field of law is because of my passion for understanding the Constitution, constitutional rights, people, and the role of the government and the role of the judiciary. This is what made me not only feel comfortable with law, compassionate with law, and develop passion for law. So, if you look at the schooling I had done, with Nani to Sirwai to Fali to Ram, you know, this kind of familiarity with people of the highest attainment in the field of law and jurisprudence, not many people would have got, but for the fact that I was associated with the Indian Express, and through Indian Express, I was fighting for this great cause, which proved to be the best years of my life. Achyut Patwardhan once told me, I don't know how many of you heard the name, he was the man who led the 1942 Quit India movement. He told me once, whatever you achieve in life, Guru, the years that you spent with the Indian Express will be the best year in your life. That is how it proved to be, because that expanded not only my vision, my knowledge, my understanding, and I was an Ekalavya of all these people, and that is how I am standing before you. Now, I'll tell you how I was encouraged. You know, in a very important criminal case from Calcutta, I wrote a 90-page complaint charging with fraud, forgery and all that. Ram told me, Guru, in my life, I have never come across a 90-page complaint. I said, Ram, I am applying the principles of conspiracy under the Calcutta rules for civil suit for this criminal case, because either we win the criminal case at the opening or lose it forever. He said, okay, I go by your assessment. And that case was approved by the High Court. The magistrate issued, you know it, what the case is. I don't want to mention the name of the case. So the process was issued, and the High Court, there was a bitter battle between Ram Jethmalani and Shanti Bhushan. Shanti Bhushan said that the complaint is 90 pages, it means that there is nothing in the complaint. That is why the weight of the complaint is now going to decide the fate of the case, or the quality of the content in it. So finally we won before the High Court. Ram was in London. I rang up Ram and told him, You know how nice he was? Guru, my judgment was wrong. This 90-page complaint won the case for us. Can you find any other great mind encouraging a small man like me and enhancing my level of confidence? This is how I became familiar with law and comfortable with law. And now coming to the issue that has been debated so far, the idea of basic features or basic structure of the Constitution. I will again take you to an anecdotal reference with Mr. Seerwai, H.M. Seerwai. You know, in 1980s, in the Indian Express had carried on a campaign against Antule. And Antule and Datta Samant joined together and they shut down the Express. And if Antule, and he was the chief minister, and Datta Samant, who was a person of physical means of handling, the people were not willing to come to the office. The journalists were afraid. Even the guards were afraid of coming to the office. So in that situation, we decided to file a writ petition. And then we decided to close down the paper. And the government refused to give permission under Section 28(o) of the Industrial Disputes Act. So we filed a writ petition where we said that there are reasonable restrictions for the right to freedom of expression, but for the right to silence, there is no restriction. Right to silence is absolute under the Constitution. This is what Seerwai was to argue. So when I went to brief him, he said, I know everything. You have said this in page 21, this in 29, this in 48, this in 62. The briefing was over in 2 minutes. So I told him, sir, I want to sit with you for some time. And you have closed the whole thing in 5 minutes. What do you want to ask? You can ask. Sir, can you tell me something about Golaknath case and Keshavananda case? I had Golaknath knocked out. I said, yes. Sir, I am a student of law. I have read your constitution books. And I am fairly familiar with how the constitutional amendments moved in 1971 onwards. Can I ask you a question? Sir, previously, the unamendability of the Constitution was limited to Part 3 of the Constitution. And that is what you fought against. That you cannot say fundamental rights cannot be amended. That was the case of the government. But you have ended up with a judgment which has extended the unamendability to the whole of the Constitution. He said, yes. This is an extreme reaction. Golaknath was a reaction. This is an extreme reaction to Golaknath. This is what we have to understand when we are talking about Keshavananda case. The political system and the judicial system, when they lose mutual trust, what happens? The political masters, the political sovereign always wants to control everything. The simple point I will mention to you, when Surya Prakash is here, he only brought it out. When the first amendment was proposed to Article 19(1)(a), the idea was Jawaharlal Nehru wanted the restrictions without the word reasonable. But all the people sat together and said, no, it's not correct. Even though you are Jawaharlal, we advise you that the restriction should be reasonable. So there was an internal mechanism in the political sovereign's mind which made the word reasonable restriction possible in the legislation. This was lost when Mrs. Gandhi came. You know what happened? Bank nationalization, and then Privy Purse case, and then the conflict between the judiciary and the executive started. And Keshavananda was one of the, Golaknath case was one of the principal drive of this. And it is true that it was a too tightly worded judgment for anyone to be comfortable with it, though it was a very well-written judgment. Not that all judgments well-written are good judgments. And so that went into the reaction. Now we do not know which part of the Constitution, and that Honorable Chief Justice Mr. Deepak Mishra listed the things which the constitutional makers did not see as the unamendable part of the Constitution. For example, it is now mentioned about the federal structure. Can India not think of tomorrow a presidential form of government? Let's assume the Constitution votes for the presidential form of government. Can the Supreme Court strike it down saying that it violates the rule of the basic structure of federal structure? You know, I think there is lack of balance. And my view is a dissenting view. Any dissenting view is an appeal to the future and brooding conscience of judiciary. This may appeal. So let us not think that the basic structure theory is so well founded. From a concrete position of unamendability of Part 3 of the Constitution, we have gone to an abstract position of unamendability of any part of the Constitution. And if the Supreme Court decides that this is the basic structure, who is to question it? For example, the NJAC case. It could well have been read down that you cannot override the two members of the judicial system, and we read it down. It's not possible. The matter would have been solved. But the question of reading it down would not have given the judiciary the position that it wants, namely that it wants independence from the government. That is also not correct. In fact, I had a discussion with the Reserve Bank Governor, Y.V. Reddy. He told me that we should be independent, but there is also some interdependence. That is how the system works. And I think that we are now 50 years after this judgment was pronounced, and there has been, as the Honorable Chief Justice said, that there has been enough empirical evidence to understand this. And I think my appeal is that the framers of the original Constitution had kept one thing in mind, that the fundamental rights of the people should not be affected, whatever is the system of governance. Now, the basic structure theory brings about a situation where the judiciary will decide the system of governance also, which is not the intention of the original framers of the Constitution. It may work for some time, but a very powerful sovereign coming, and powerful sovereign can be produced by democracy. It's not that powerful sovereign will be produced by any method other than democracy in India. Such a person may take a position. Again, a confrontation can come between the judiciary and the legislature. I think it would be within my rights as a citizen to appeal to the judicial fraternity and also the entire intellectual basis of judicial functioning, law, courts, that we should have a re-look at the basic structure theory. And with that, I finally want to say only one thing. I have been seeing what's happening in the last 40 years. The state of the court, the state of the bar, the state of the media, the state of the discourse. Now Ram is not there. We see a dwarfing. All tall people, when they disappear, we don't see an equivalent person on the horizon. We need tall people, sun-crowned, and they cannot come. If they are going to discuss only about their fee structure for cases and the turnover that they achieve in a month or in a year, we have to move away from all. At least some people have to move away from all this. Tall people cannot be produced by mere money making. In fact, tall people are those who keep away from this. So we need to pray for, as the American senator did when the Watergate case was going on. He said we need tall people, sun-crowned, who live above the fog of, I forget the full poem, it's a beautiful poem. And with a drop in his eyes, he closed, saying that no system will work unless there are tall people. We have to produce tall people. Thank you very much.
Thank you very much, Mr. Gurmurthy. As always, pleasure hearing you. Our final keynote speaker this evening is a senior advocate and one of the foremost constitutional lawyers who's been part of milestone cases like decriminalizing homosexuality and the right to privacy as a fundamental right. He regularly argues on constitutional matters and has literally written the book on environmental law in India. Let's put our hands together for Shyam Devan.
Thank you very much for that. Minister, Chief Justice, members of Parliament, eminent jurists, journalists, members of the Jethmalani family, ladies and gentlemen. Let me as well begin with my tribute to the person whose memory we today mark. I'll share with you two early encounters. The first was when I was in class 8 in 1975, and my father suggested that I visit the Bombay High Court to hear Ram Jethmalani in a critical case for preserving our liberties. This was 1975, late 75. It was during the emergency, and the case was titled N.P. Nathwani versus the Commissioner of Police. It was my first visit to the Bombay High Court and to the Chief Justice's Court, and the bench comprised Chief Justice Kantawala and Justice Tulsapurkar, who later on, of course, came to the Supreme Court of India. The judgment is reported in volume 78 of the Bombay Law Reporter at page 1, and it records the appearances N.A. Palkhiwala with R. Jethmalani, K.S. Cooper, A.B. Diwan, S.J. Sorabji, and 153 other advocates as per the list handed over by Gagrat and Company. The Commissioner of Police had refused permission to a group of lawyers to hold a private meeting to discuss the preservation and promotion of civil liberties and the rule of law. The bench unanimously, there are two judgments, one by the Chief Justice, one by Justice Tulsapurkar, they preserved the ancient right of assembly and quashed the police commissioner's prohibitory order, which prevented the lawyers, or which had prevented the lawyers from convening the meeting. Ram's advocacy was stirring. If my math is correct, he was 52 at that time, but his presence and his powerful advocacy transformed the court into a theater. It was a mesmerizing experience for a schoolboy and an early lesson on the indispensable role of lawyers and judges in preserving liberty. The last paragraph of the law report sort of piqued my interest, so I'll read it to you. It goes this way. It says, Mr. Sorabji on behalf, and this is what Mr. Gurumurthy had also mentioned. Mr. Sorabji on behalf of the petitioner stated that counsel and attorneys appearing for the petitioners are not charging any fees and will be only pressing an order of costs restricted to the mere out-of-pocket expenses incurred, of which a statement is handed over. In view of this statement, the respondents are directed to pay the petitioners a sum of rupees 3,742 and 51 naya paise, being the out-of-pocket expenses incurred by the petitioners. So it was a small triumph at a very dark time in our history, no doubt made sweeter by the 3,742.51 rupees which the police commissioner was required to pay. My second early recollection, was in the year 1977. So we are 2 years on. And by then, Ram had left India. He'd left India in 76 during the emergency and had returned to contest the Lok Sabha elections. He ran against the serving law minister, H.R. Gokhale, in the Bombay Northwest constituency. And I remember attending a meeting at Marine Lines in Mumbai. There was a hall where the opposition candidates were all on the stage, but not Ram. Where was Ram Jethmalani? Midway through the meeting, there was a slight commotion, and in strode Ram to great cheers and applause. I remember him walking onto the stage, apologizing for being late, and heading straight to that Chicago radio microphone. And then he declared, "The Hun is on the run." The audience was stunned. What was Ram Jethmalani talking about? And then he went on to say that the Prime Minister's intelligence agencies had projected a very bleak prospect for her, and that she was set to flee the country. That is why the Hun is on the run. These encounters distilled for me some of Ram Jethmalani's great qualities: courage, an unflinching focus on freedom, an actor's way with words, and fearlessness for the cause of the client. Let me move on now to basic structure. And frankly, I thought that by now, as the last speaker, this ground would have been covered. But let me just share with you a little nugget. The notion of basic structure, which has been explained by the speakers ahead of me, actually started with a German professor, Dieter Conrad. And he delivered a lecture at Banaras Hindu University where he propounded a theory that some things in the Constitution are immutable or are unchangeable. And barrister M.K. Nambiar, who argued Golaknath, found out about the Conrad lecture through his friend T.S. Ramarao, a law professor at the Madras University. So this is how it was run initially in Golaknath, and then of course Palkhiwala took it to a whole new level insofar as the Keshavananda Bharati case is concerned. Let me just indicate a couple of factors as I understand them in terms of context, because I think political context is very important to understand and justify the basic structure doctrine and why it's so important for us here in India. So it was mentioned that there was the popular government had pushed through and made efforts at a large number of laws which sought land reforms, privy purse was mentioned, bank nationalization, taking over of other land and assets was mentioned, and therefore a clear attack, not just at Part 3, which is fundamental rights, but also a constant testing of the bounds of judicial review. What can be done? How far can the courts go? How far should the courts go? And allied to this searching interrogation on the limits of law in terms of judicial review is another aspect of our constitutional model. And that really is what I think Mr. Nariman mentioned, that our Constitution has been amended 105 times in 73 years. 105 times in 73 years. Now contrast that with the United States Constitution, which has been amended 27 times in 234 years. Or consider the Japanese Constitution, which hasn't been amended even once since 1946. In Australia, in 121 years, it has been amended just 8 times. So what you have is that, we have a great regard for our Constitution. We have a great regard for constitutional sanction. And a result of that is that we have certain provisions which I suspect don't make their way into many other constitutions. For example, just ahead of a chapter which is, loftily titled Relations Between Union and States, very important, Part 11 of the Constitution, or the Scheduled and Tribal Areas, which is Part 10 of the Constitution, is a whole chapter in our Constitution beginning with Article 243ZH, and it is titled Cooperative Societies. Now, I can scarce imagine that there would be parts, that there'd be too many constitutions anywhere in the world which has cooperative societies right up there in your basic and foundational document. But we have it. And so there are several parts which, of course, can be removed, which can be amended, which can be altered. But then there are others, I suspect, Part 3, for example, with some exceptions, which must hold out if we are to preserve our democracy. So Article 368, which was also referred to, is the great constitutional provision by which the Constitution itself comes to be amended from time to time. And here I'd like to borrow Nani Palkhiwala's phrase, deface and defile. And what he says is, and what he writes is, that does the constitutional amendment, the question or the test is, does the constitutional amendment deface and defile our great charter beyond recognition with respect to any of its essential traits? Palkhiwala ends his 1974 book, Our Constitution Defaced and Defiled, with a caution. The amending power under Article 368 is not a death wish or a provision for legal suicide. To quote him, the nation may pass through times like the present when it suffers a loss of identity, but never the Constitution. The founders had an unshakable faith that however stormy the days, the preservation of the identity of the Constitution will always enable the nation to come back into its own. And so the basic structure doctrine is really about protecting the essential identity of the Constitution. Very briefly, I think many of these doctrines in law are tested or are valid depending on their utility. I believe it's been of tremendous utility for us here in India in preserving crucial aspects of the Constitution, such as, for example, the scope of judicial review and the power of the court, or reserving to the court or our higher judiciary the power to strike down legislation which otherwise falls foul of constitutional provisions, and a few other areas also where the basic structure doctrine has been applied to preserve liberties, to ensure that our democracy remains intact and doesn't suffer too many inroads in terms of rule of law. And as Mr. Nariman mentioned, this doctrine has found resonance beyond our shores. So we have the doctrine applied to strike down constitutional amendments in Bangladesh, in Belize, as was mentioned by Mr. Nariman as well, where the 8th constitutional amendment of 2011 was struck down because it was found to make too much of an ingress in terms of destroying property rights. Kenya has used and employed the doctrine for striking down one of their constitutional bills. Uganda as well. Malaysia as well, after a little bit of back and forth. And Pakistan has adopted this particular doctrine. Singapore found that the basic structure doctrine is not really aligned to their constitutional form, their history, and so they rejected it. I had the advantage of access to a manuscript which my father maintained during the Keshavananda Bharati case. So as was told to you, there were 13, it was the biggest and strongest panel in our Supreme Court, 13 learned judges. Nani Palkhiwala was leading the charge on behalf of the petitioners. There was H.M. Sirvai, who was leading the defense of the constitutional amendments on behalf of the states. And this is what my father penned on Thursday, December the 21st, 1972, from his manuscript, 30th hearing, 3:40 p.m. Nani Palkhiwala. In another 20 minutes, I will have done. I will end as I began on the question of approach with a few well-chosen and well-phrased words of a distinguished lawyer. I would, however, request your lordships not to read the name of the author. Palkhiwala given cyclostyle bunch, which he hands over to the court master. I again request your lordships not to read the name, because if you do, you will not believe your eyes. The name is H.M. Sirvai. Laughter. 3 interruptions by Sirvai. Sirvai. Articles written, Member of Parliament in the Select Committee told me that certain clauses were dropped because of my articles. Nani Palkhiwala, thank you. Sirvai, I will fully explain the articles. Nani Palkhiwala, you will do so at length when your turn comes. Justice Hegde shows that judges and lawyers should not write articles. Justice Chandrachud, Y.V. Chandrachud, Mr. Palkhiwala, have you not committed a breach of copyright? Laughter. The punch in Palkhiwala's closing submissions is revealed on a reading of Sirvai's passionate defense of the right to property in a series of 3 articles that had appeared in the Times of India 17 years before Keshavananda Bharati was argued. So let me end with some words from Jethmalani, Ram Jethmalani, on Nani Palkhiwala. And when Palkhiwala passed in June 2004, this is what Mr. Jethmalani had to say. I believe that Nani's greatest contribution in the field of constitutional law was his glorious success in the Keshavananda Bharati case. Nani had realized that the Constitution had been treated with even less respect than is due to the Cattle Trespass Act. He brought in his complete legal expertise and repertoire to sustain a unique proposition. Whatever be the width of the amending power of the Constitution, you cannot, by any kind of majority vote, alter or destroy its basic structure and framework. The government of the day made an inglorious attempt to have Keshavananda judgment reviewed and reversed. Fortunately, the judges did not accept the invitation. The doctrine is now an incontrovertible part of our constitutional jurisprudence, and India is spared the danger of demise of its democracy. The judgments of our court and the judgments of the overseas courts which have upheld basic structure use expressions like pillars, supports. These are the great supports and the pillars of our constitutional edifice. But to end, let us also remember that in addition to the pillars and the supports, we need spaces. We need spaces for our citizens. We need spaces for the citizenry speaking through civil society. We cannot possibly afford a situation where there is no space for a comedian, there is no space for a journalist, there's no space for a cartoonist, there's no space for an academic. So the defense of democracy, assured, at least for a while, by this important utilitarian principle of basic structure, also requires each one of us, like the very eminent lawyers mentioned in the past, to ensure that the spaces do not shrink any further. I thank you very much, and I thank Mahesh for this. Thank you.
Shyamji, many thanks to you. It's been a delightful evening. And as a last part of the proceedings, it's our proud privilege to announce to you something that is as larger than life, worth doing, and special as the legendary man it seeks to honor. The Sunday Guardian Foundation, in the memory of Ram Jethmalani on his birth centenary, has formulated the Will of Steel Awards. Under the auspices of these awards, we today confer the first inaugural Ram Jethmalani Prizes for Journalism. Honored dignitaries, ladies and gentlemen, the awards being conferred today now constitute the grandest purse-carrying award for journalism in the whole world. The main winner today will walk away with a check of 14 lakh rupees and a gold medal, a purse that is larger than the Pulitzer Prize. In this inaugural year, this has been open to journalists from India. It's aimed that next year it will be open to the best in the fourth estate from the entire world. We've been privileged of having an amazing jury who have deliberated and voted for the worthy winners. Let's unveil the jury names and the awards, please. Could I request Shri Mahesh Jethmalani and Shri Kartikeya Sharma, Member of Parliament, to kindly escort our guest of honor, Shri Arjun Ram Meghwal, Union Law Minister, to the front of the stage for the conferment of the first award, the Ram Jethmalani Prize for the Service of Humanity. Let's reveal the shortlist and the winner, please.
The Jethmalani Prize for Journalism in Service to Humanity, to be awarded for rare and noble contribution for the promotion of democracy, good governance in the spirit of Vasudeva Kutumbakam, one world, one family. The shortlisted nominations are Aditya Raj Kaur, Naveen Suri, Hemant Parekh and Hira Azmat. The winner of the Wheel of Steel Awards Jethmalani Prize for Journalism in Service to Humanity is Aditya Raj Kaur, Executive Editor, TV9 Network.
Let's keep the award going. Let's keep the applause going. Is the first one in what we hope is a series of many. Aditya, many, many congratulations. The next category of the awards, because of course we can't have an award ceremony with Ram Jethmalani name attached to it and not acknowledge legal journalism. Can we have the next category shortlist, please?
The Jethmalani Prize for Legal Journalism, for the most effective use of mass media to disseminate accurate information in public interest of legal proceedings, judgments and legislations. The shortlisted nominations are Bar and Bench, Apurva Mandhani, Assistant Editor, The Print, Sadaf Modak, Principal Correspondent, The Indian Express. The winner of the Wheel of Steel Awards, the Jethmalani Prize for Legal Journalism is Bar and Bench.
Could I request Pallavi Saluja, Debian Roy and Amir Khan to join us on the stage and receive the award, please? Many congratulations, Team Bar and Bench, Pallavi, Devian, and Amir. The third and final award conferment is the Jethmalani Prize for Empowerment. Can we have the shortlist and the winners, please?
The Jethmalani Prize for Empowerment, for the most effective promotion of gender empowerment, social upliftment of tribals and marginalized groups. The shortlisted nominations are Hina Rothki, Deepan Vitanayogi, Ekta Kapoor and Vishal Bharti. The winner of the Wheel of Steel Awards, the Jethmalani Prize for Empowerment is Hina Rothki, Special Correspondent, The Indian Express.
Hina ji, if you could join us on stage. As we culminate this evening, Arjun ji, Mr. Meghwal, could I request you, sir, for both Mahesh ji and for Karthike ji, gentlemen, if you could stay with us, we have a special memento to carry away from this evening. Meghwal ji, if you could present this first to Shri Mahesh Jethmalani. And the second one to Shri Kartikeya Sharma, who has been gracious enough to support the formulation through the Sunday Guardian Foundation. With that, I request Shri Kartikeya Sharma, Member of Parliament, to kindly give us the vote of thanks.
I would like to extend my gratitude to everyone on behalf of the Sunday Guardian Foundation for coming and celebrating the life and force that was Mr. Ram Jethmalani. Like many others here, I knew him personally and can say with authority that Ram was not only a leading legal luminary for decades, but he also influenced many communities from different fields. He was the chairman and the founder of our paper, The Sunday Guardian, and wrote extensively with unimaginable grit and conviction. I and my team conceptualized the idea for the Will of Steel Awards in journalism, as Ram was an embodiment of it in every sense, and it would encourage journalists who work hard every day to get us news out there despite all odds. I would like to thank our chief guest, Honorable Chief Justice of India, D.Y. Chandrachudji, for taking out time for the event, our guest of honor, Honorable Law Minister Arjun Ram Meghwalji, for gracing us with your presence, sir. I would also like to thank our guest of honor, Attorney General of India, Shri R. Venkatramani, for taking out time. Our keynote speakers, Justice Deepak Mishra, Senior Advocate Fali Nariman, Shri S. Gurumurthy ji, and Senior Advocate Shyam Devan, for such a thought-provoking discussion which has left us with a lot to ponder on. I would also like to thank Mr. Mahesh Jethmalani for his support for this event and being patient in the entire planning and the execution of the event. I would like to thank the team and the teams who've worked tirelessly for the execution of the event, and would also like to thank the esteemed jury led by Justice Bobre, who took out time to select the winners from the many entries that we received for the Will of Steel. I would like to congratulate the winners of the Will of Steel Awards, and awards are a testament of your hard work, your desire to report and get stories out there despite the very many challenges that there are in the world today. Thank you very much. Thank you.
Thank you, Shri Kartikeya ji. And with that, ladies and gentlemen, we conclude the Centenary Ram Jethmalani Memorial Lecture. Thank you for your time and for your patience, and to all our guests and dignitaries.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.